In January this year, the Supreme Court denied bail to former JNU student leader Umar Khalid and activist Sharjeel Imam in the Delhi riots conspiracy case. Both had already spent nearly 6 years in jail without trial. The court said that under the UAPA, India's anti-terror law, the standard for bail is much stricter, and that long incarceration alone cannot justify release. But now, just a few months later, another Supreme Court bench appears to be taking a very different view. While hearing a separate UAPA-linked case from Jammu and Kashmir on May 18th, the judges made a striking observation. Bail is the rule, even in UAPA cases. The bench also warned that keeping undertrials in prison for years before conviction risks turning the process itself into punishment. And that has once again brought the spotlight back on the UAPA. And one question in particular. How long can someone remain in jail before trial in the name of national security? The UAPA was first introduced in 1967. But over the decades, it evolved into India's main anti-terror law, especially after laws like TADA and POTA were repealed. Today, the law deals with terrorism, terror funding, unlawful organizations, and threats to national security. But one provision has remained especially controversial. Section 43D(5), the bail clause. Under regular criminal law, bail is usually the norm. But under the UAPA, courts can deny bail if they believe the accusations against the accused are prima facie true. Critics say this makes bail extremely difficult because courts often rely heavily on the prosecution's version at the early stage of a case, while trials themselves can take years to begin. The law also allows investigating agencies more time to file charge sheets, up to 180 days, instead of the usual 90. And this is where the debate around personal liberty becomes central. Back in 2021, in the K.A. Najib case, the Supreme Court had ruled that even under stringent laws like the UAPA, courts could still grant bail if there was no realistic possibility of a speedy trial. The judgment had stressed an important principle: the stricter the law, the faster the trial should be. But in the January 2026 ruling denying bail to Khalid and Imam, the court took a narrower approach. The judges described the two as alleged ideological drivers of the conspiracy behind the Delhi riots, placing them in a different category from 5 co-accused who were granted bail as local facilitators. The court also adopted a broader interpretation of what could count as a terrorist act under the UAPA. It said that large-scale road blockades and disruption of civic life during the 2020 visit of then US President Donald Trump could, prima facie, fall within the scope of terrorism if they threatened economic security or public order. Critics argued that this risked expanding anti-terror law into the space of protest and dissent. Now, the latest observations from the Supreme Court suggest there may be some reconsideration happening within the judiciary itself. The bench said courts cannot mechanically accept the prosecution's version while deciding bail, because that could leave undertrials imprisoned for years without conviction. The remarks have also revived conversations around several other UAPA cases, including that of tribal rights activist Stan Swamy, who died in custody in 2021 while awaiting trial in the Elgar Parishad case. Supporters of strict anti-terror laws argue that cases linked to national security require tougher safeguards. Critics, however, say delayed trials and harsh bail conditions can end up punishing people long before guilt is established in court. The Supreme Court has not overturned its earlier rulings, but its latest remarks suggest that the debate around personal liberty, dissent, and India's anti-terror laws is far from over.